There
How
we
about
go.
now?
Now we got
Yeah.
it.
Okay,
Yeah.
now we're good. By the way, we got a couple of emails the last couple of days about the links to the video presentations of our presentations in January. They're on our YouTube channel. And we'll send out a link to those, but we're gonna start posting these on our Harker Lepore YouTube channel. So the next few slides are screenshots from a court case involving a homeowners association who attempted to make some amendments to the governing documents. And I'll kind of summarize it. In 2004, the association filed and recorded an amendment to the CC&Rs. By the way, anytime you see the phrase restrictive covenant, all that means is CC&Rs, okay? So CC&Rs are restrictive covenants. The 2004 amendment prohibited manufactured homes in the subdivision and provided that all construction in the subdivision must be approved by the newly created Architectural Control Committee. Now, many of you have Architectural Control Committees. Some of you have Architectural Review Committees, ACCs, ARCs, same idea. The document was executed by the association's officers and the signatures were notarized. The document recited that at least 75% of the subdivision landowners had approved. And there were 34 pages of signatures. Now let's go on. Mr. Resolve files a lawsuit against the association a few years later. And he began preparing the lot to put a manufactured home in. In other words, doing exactly what this proposed amendment was trying to prohibit. So the association sends Rizlov a letter and says, hey, sir, take a look at the 2004 amendment that prohibits manufactured homes. What you're about to do or what you're planning on doing is prohibited. Stop it. The lot owner disagrees and a lawsuit ensues. Now, this is the court. It says it's plain enough in paragraph 14 that it requires any instrument amending the covenants to be executed and acknowledged in the form prescribed by the execution of deeds. Now, this is a Wyoming case, by the way. The parties disagree about, however, whose signatures must be notarized. Here's the conclusion. So they were signed and they attached 34 pages of signature sheets, but none of those were notarized. And the governing document said, hey, if you want to amend this, you got to have signature and notary. Here's the conclusion. The 2004 amendment to the covenant is invalid. And that owner gets to put the manufactured home in because they didn't comply with one of those technicalities, which is they had to be not only signed, but notarized, okay? So my point in telling you this is that many of you have governing documents with strange language. In fact, Bruce, I'm going to turn it over to you for a couple of minutes to talk about the language in Joni's documents.
I'm not going to talk about any particular client.
Not particular,
here.
but talk about the complexities sometimes when you see language about amending governing documents.
I mean, honestly, that one didn't have a lot of particulars in terms of the procedural aspects, in terms of who had to notarize, who had to sign, and so on. The issue we were dealing with there was with the statutory provision under 6490, which has an interesting provision that says that if your CC&Rs require a percentage greater than 67%, and then you vote and you get at least 67%, but less than the percentage in the CC&Rs, then you can bring an action in court asking the court to approve the amendment.
Yes.
Which is an unusual circumstance. So that's the only place I've ever seen that is in RCW 6490.
Gotcha. Now, I've thrown around this phrase governing documents, and by that I mean the following. Your declaration or CC&Rs. Now, one of the interesting things in the law is just sort of the vocabulary that develops. And so for whatever reason, generally speaking, with condominiums, we call that document the declaration. In non-condos, we often call it CC&Rs. It's the same thing. It's a declaration of covenants, conditions, and restrictions. Also within that umbrella of governing documents is the plat, and we'll talk about that more in a moment. Your bylaws, your articles of incorporation, and then your rules and regulations. Now, here's my first of maybe 3 trivia questions. Which of these governing documents are recorded in the county recorder's office?
Declaration
Yep,
for the CCNRs.
yep. What else?
Bylaws.
The bylaws, but you told me that they were recorded, but then if there was a change after 5 years, they didn't have to be re-recorded.
So Tiana, you must be in a condominium in Oregon.
Yes.
Y'all see how smart I am right there? Okay. I'm just kidding. We'll talk about those technicalities at the very end. Yeah. In most associations, the bylaws are recorded. Some older associations, the bylaws might not be recorded, but in general, they're recorded. And then the articles of incorporation. Most of you are incorporated as nonprofits. Those aren't the articles of incorporation aren't recorded in that sense. They are filed with the Secretary of State. So based on the folks here, about half of you are in Washington, half of you are in Oregon, but those articles of incorporation go to the Capitol, they get filed, and that is your nonprofit corporation status. Now, your rules and regulations, those are generally not recorded. And within that sort of umbrella, I include resolutions, architectural guide, those unrecorded restrictions like rules and regulations. Now, let's talk about each one of those for a moment. But before I do that, I've been doing this for many, many years, and I have come across several times situations where new association hires us and I say, okay, let's get started. Send me over your governing documents. And what I get is a Word document of their CC&Rs. And the reason I get that is because years ago, some very sweet, smart person with too much time on their hands decided to retype the CC&Rs in an easy to read, easy to understand format. And part of me finds that admirable. It's a lot of work, but don't do that. Always use the recorded version of those recorded documents. And it's very easy to determine that. If it's recorded in Oregon or Washington, on the very first page, you're going to see some form of recording information. Usually the first 4 digits of the year, and then a dash, and then a random string of digits. Some associations, older ones particularly, they might be using a book and page recording system. So this is recorded in book 1231, page 1729. But it's important, especially when it comes to your CC&Rs and bylaws, that you are recording and using the version that is legitimate and not some recreation or easy to read, easy to understand version, okay? Now, I'm going to talk about each of these documents in turn, and then we'll dive into the process of amending. And we'll start with the declaration of CC&Rs. Now, covenants. The way I always explain CC&Rs is they're promises. And a lot of owners, when they buy into community associations, don't even realize that they are promising not to do or to do certain things. For example, they're promising to pay their assessments. They're promising not to create nuisances. And Bruce, I'm about to turn it over to you. How do courts interpret covenants? Compare that with a contract. And if a dispute arises with covenants, how are they interpreted?
They're interpreted as contracts.
All right, that was too easy. But the weird thing about it is when you buy into one of these communities and you become an owner, you're automatically a member of the association. And you have contractually agreed to abide by the covenants, whether you read them or not. And that's what's a little different about a traditional contract. But yeah, like Bruce said, these are interpreted as contractual agreements. Generally, they're between all of the owners within the development. Most of the time, they're adjacent parcels or adjacent units. Now, what's the big difference between a contract and a covenant? The big difference is that a covenant binds subsequent owners. So if a developer records CC&Rs or covenants today, it's going to bind all of the future owners 20, 50, 80, 100 years from now. And that's one of the big differences between a contract and covenants, is that it applies to subsequent owners. All right. Now, the CC&Rs or declaration, I always refer to that as sort of the constitution of the community. It lays out who owns what, sets forth the easement rights. In a planned community, generally owners have the right to use and enjoy the common areas. In a condominium, owners have the right to use and enjoy common elements. The CC&Rs, the declaration, also is the document that gives the association the authority to levy and collect assessments. It's also the one that sets forth the use restrictions. Now, for you folks in Oregon, for condominiums, the use restrictions, and this is very unusual, the use restrictions are not in your CC&Rs, they're actually in your bylaws. So that's one big difference in Oregon condominiums. But yeah, what you can and cannot do is generally going to be in the CC&Rs. All right, now, who can tell me what this map is called? What do you call this map? Anyone know?
It's a plat.
Bruce? You're wrong. And Bruce knows he's wrong. What do you call this? Who said tax map? Lawrence. Yes, why did you say that? How do you know this is a tax map?
I'm a land surveyor. I've seen a lot of
Oh, who do you work for?
them. Eugene Wabi.
Right on. My dad is a surveyor in Washington and Oregon. He used to work for Compass Surveying in Milwaukee, Oregon.
I've heard of them.
Yeah. I hope you have heard of the Harker name. We're a pretty big name in Oregon. And no, I'm just kidding. So yeah, this is an assessor's map. And
They usually steal my plat to make it to begin with. So.
yes, that means. So Lawrence, we have a lot. I love surveyors, and we have a lot to talk about. But I'm glad to have met you virtually. But yeah, this Lawrence is right. This is an assessor's map. So one of the governing documents I mentioned is your plat map. Wherever that slide went, here it is, plat. And, you know, a lot of folks, when they buy property, they get their preliminary title report, and frequently the title companies attach this map, an assessor's map. And it's a quick, easy, visual way to identify the property. But do not rely on this map for anything except the county assessor number, okay? And let me explain why. So the next, I'm about to show you the actual plat for this subdivision, okay? Now this is the plat. And on the plat, I learned all sorts of fun information. For example, that there's a sewer easement that runs the entire length of this parcel. And that sewer easement, if I want to learn more about it, I can go to book. Got to get my glasses. I'm getting old. Now I'm only in my late 20s, but I'm going to put my, no, I'm just kidding. In book 858, page 970. Also look, oh, interesting. That's also common property. Sewer easement running the entire length of these lots. And then I have an access easement over here. And the only place you'll find that access easement is right here on the plat. It's not separately recorded. So this plat gives me all sorts of fun information. Now, here's my question for you. Suppose the CC&Rs for this subdivision say all lots shall pay one annual assessment. And I'm the owner of lot 1 right here. And for whatever reason, I have created 3 tax lots over the years. How many assessments do I pay? Do I pay 3 or do I pay 1?
One,
Lawrence, I hope you said one.
one.
That was
Good.
another Lawrence.
Yeah, one. Because when you see the reference to lot in in the CCNRs, that's always going to be referring to the platted lots, the legal lots of records. Tax lots mean nothing except for county tax purposes, okay? Now, depending on what county you're in, it might be very easy. So those like Joni, where'd Joni go? Are you still here, Joni? Bruce, did we lose Joni?
I can't say. for
I'm
sure.
sorry. I'm
Oh,
sorry.
there's Joni. So Joni's in Clark County. Clark County, Washington has an excellent data portal for plat surveys. Washington County, Oregon, Multnomah County, Clackamas, Tri-County area, excellent websites. You can get all of these documents. Now, Dennis,
Yes,
out in Tillamook County, it's a whole nother ballgame and it's a little tricky to get these,
I could imagine.
but it's doable. But the reason I point this out is I've shown up at association or board meetings and they've handed me their binder of governing documents. And when I go to the plat page, it's not the plat, it's the assessor map, and that's bad. And so my point in this little exercise is to show to you folks, there's a huge difference between an assessor map and a recorded plat or survey. That's my point in telling you, okay? All right, now we're going to move on to the next of the governing documents, which is the
Kevin, do you know that
bylaw.
you stopped sharing your screen?
Oh, I did? Shucks. Thank you, Bruce. We back?
Yeah.
The bylaws. I refer to the bylaws as sort of the operating guidelines. That's the document that says when you're supposed to have meetings, what your quorum requirement is. For Oregon condominiums, that's where your use restrictions are going to go. And again, most communities, the bylaws are going to be recorded. Some older communities, they might not be recorded, but in general they are. So that's the bylaws. Now, next in the governing documents are the rules, regulations, and resolutions. And these are not recorded. And so it's always important to make sure that new owners in communities get copies of rules, regulations, and resolutions. And in most cases, the board of directors has the authority to adopt unilaterally, without a vote of the owners or members, rules and regulations. You cannot adopt a rule that conflicts with the CCNRs or bylaws. And again, they're generally not recorded. Have any of you heard the phrase or term restatement?
Oh, yeah.
Yes. I'm going to turn it over to Bruce for a few minutes to explain that difference.
Restatement is just a process by which prior amendments are collected into a single document so that it's clearer, and you're simply restating all of the covenants as they are now and have been amended without making any substantive changes, as opposed to an amendment where you're changing some substantive provision of the documents. A lot of times you'll see amended and restated, and those are really two different procedures that I guess sometimes are happening simultaneously, where you're getting a vote of the membership to adopt an amendment. A restatement typically can be done by the board of directors without a vote of the membership, so long as you're not changing something substantive in the documents themselves. So you'll see amended and restated a lot sort of used together, but they are really different processes.
Everyone, I'm back. I went and refilled my water.
Oh.
But, all right, now let's talk about reasons to amend. Bruce, let me ask you something. Have you ever had a HOA or condo board come to you, say, hey, we want to amend, and it wasn't a really good reason to amend?
Oh yeah, all the time.
Yeah, same.
What's the most common reason that you've heard that you think is not a good idea?
So the most common reason is, oh, I heard that the legislature changed the law do we need to amend our governing documents to reflect that change? That's probably, in my experience, the most common reason. What about you,
The
Bruce?
most common for me is when associations call and say, our documents really haven't been changed in a long time. And I feel like they just need to be modernized.
Yeah, that's another one. Like, we just want to amend them because I'll be honest with you, Bruce and I have, I don't know how many CCNRs and bylaws collectively we have read in our time as lawyers, but a lot. And I'll be honest, some of the best governing documents are ones that were recorded in the 1960s. They're pretty broad, but give the association authority. And some of those are really, really well-written documents. I've seen others recorded in the past couple of years, and it's clear that the developer cut and pasted some language from other CCNRs, did not use a lawyer, and they're usually pretty poorly drafted. But other reasons, legitimate reasons, sometimes the drafter of those documents, sometimes the language is ambiguous, doesn't make sense. And maybe there's 3 or 4 different ways to interpret what the intent was with that language. Sometimes associations come to us and say, hey, our CCNRs were recorded 20 years ago, but in the last 20 years, things have changed. For example, maybe the CCNRs, when they were recorded, say that all homes must have cedar shake roofing. And many of you may know that cedar shake roofing has fallen out of favor. It's a fire hazard. If there's a fire, they catch on fire and they can burn quickly. And so, a lot of new construction over the last 20 years has moved away from that. That's a good reason to amend. Or sometimes the demographic changes, a lot of renters, a lot of investment properties. Maybe that's a good reason to amend. Sometimes associations come to us and say, we're pretty happy with our governing documents, but there's so many provisions relating to the developer or declarant's rights. We just want to clean that up and remove it. That's fine. We'll do that for you, but I don't know that that's necessarily on its own a reason to go through the time and expense to go through the amendment process. Now, the amendments that we frequently are asked to draft, rental amendments is a big one. Sometimes we will draft them in such a way that a percentage of the lots or units may be rented. Sometimes just a flat out number, only 3 out of the 100 lots may be rented at any given time. We've also been doing a lot of smoking amendments. Prohibitions, particularly in condominiums, of smoking any substance in areas that are classified as general common elements. Parking, number of directors. We've had over the years associations where the developer, when they wrote the documents, put in that the board of directors shall be governed by 7 individuals, and it's a 20 lot subdivision, and it's hard to get even 3 individuals to step up and run. So we will sometimes do amendments to reduce the number of directors. Sometimes we do it to increase the number of directors. Ken Miller, how are you? When did you pop in?
A little bit ago, whatever.
No, let me, for those of you that don't know Ken is been on the board of many condo and HOAs. He's also a real estate agent and specializes in King City, Oregon. And for those of you not familiar with King City, that's where people go to retire. And it's a lovely place. It's mostly 55 plus communities. But Ken, good to see you.
Yeah, they'll be rolling up the sidewalks at 7, so.
Yeah, and everyone had dinner at 4 o'clock. So that's wonderful.
Yeah.
Bruce.
Yeah.
I'm going to give this question in the chat box to you, which is, can you only do non-smoking amendments in common elements, or can you make the entire building smoke-free?
I think you can make the entire building smoke-free so long as you get 75% of the owners to vote in favor of that amendment. I suppose that the threshold, that's specifically speaking about Oregon. The threshold may be different in Washington. But you would need to make that a CCNR amendment. Now, Washington's interesting. Washington has some interesting case law about what you need in order to add a completely new restriction in, as opposed to amending existing restrictions. So I guess I shouldn't give you any blanket statements about what the threshold is, but I do think it is possible to amend the documents to put in a smoking restriction that would prohibit people from smoking inside their unit. So long as, on a case by case basis, you'd have to look at what the approval threshold is for that.
Yeah, I agree. Now let's talk about the process for a moment. I think it's critical and important to be able to explain to the owners the reasons why you're amending. And then I like to go through sort of the rest of these bullet points, which is statutory and voting requirements. As Bruce just pointed out, Oregon generally to amend the CCNRs is 75%. Those of you in Washington, it could be different, sometimes 67% or 2/3. And again, this is why I always give that caveat, which is your documents might be have something very different than what we're talking about. Bylaws, generally speaking, require a majority to change, but there's also a lot of bylaws that can be amended with just a simple majority of the board. So again, the big part of the process is determining how many votes you need. The next step in my mind is deciding on the method of voting. And in Washington and Oregon for the last several years, statutorily, we've been able to do electronic voting, which in my experience, we have a much larger voter turnout. I think there's something about the ability for folks to turn on their phone in the comfort of their living room and cast a vote versus having to show up at a meeting, fill out a paper ballot. And so electronic voting or votes by written ballot in lieu of a meeting, in my experience, generally you get a larger voter turnout. But there are different ways of voting, and we'll talk about those in just a few minutes. Now, one of the other things in most cases that I recommend is soliciting feedback or having a town hall meeting. And here's the story I always give. About 10 years ago, I was redoing and amending the CCNRs and the bylaws for a big planned community. And we had gotten a draft together that was pretty good. And we had spent almost 4 months. There was a committee involved and the board. And we had a pretty good set of documents. And we have this town hall meeting and about 300 owners show up. And about 200 of the 300, all they cared about was the language that I had written in the provision that governs Christmas lights. And the way that I had written it and the way that the board had interpreted it, the way the committee had interpreted it, was that it was certainly allowed. But about 200 of the owners, the way they read it, it wasn't. And it was a good learning lesson for me, which is, I know that 99.9% of everything I write is perfect. I'll tell all of it. I'm kidding. I am kidding. But the lesson I learned there was, if I hadn't got that feedback and we had put it out to a vote, it wouldn't have passed because of some language in this very specific provision about Christmas lights. That's what everyone cared about. And I didn't know that. And I wouldn't have known that unless I had that town hall meeting. And so I think go ahead, Bruce.
I'll add kind of another story similar to that was actually a really sort of upsetting story for the client, but essentially it was an HOA that was looking to modernize their documents, and we went through an entire process of making really very minor, proposing very minor amendments that really didn't change the substantive rules in much significant way. But when we put it out to a vote, the board learned that there was such a level of distrust amongst the community that people were going to vote no kind of to whatever they proposed. And I think, again, having gone through maybe a process where there was more feedback and more reach out to the community ahead of time may have avoided having gone through the process of, the expense of drafting and proposing without getting the actual approval.
Yeah. Bruce, let's take a couple of questions from the chat box. The first one, does Oregon require signatures to be notarized? Not necessarily. In fact, most modern CCNRs and bylaws do not require notarization. Usually all that's required is that the current board chairperson and secretary sign a certification that the requisite votes were received. Now, some older documents might say that in order for an amendment to be valid, there must be signatures that are notarized by the, and if you have that language, you got to comply with that.
So are you
Bruce?
saying the president and secretary, when they certify, that certification does not need to be notarized?
That needs to be notarized, but not the individual
Right.
owners. Yes,
Okay.
thank you.
Right. Yeah.
Bruce, I'll let you take the next one from Pamela,
Oh, you skipped one, which was, is it easier to remove restrictions?
it
And the answer
depends.
is really, it's the same.
It depends on the appetite of the owners.
Right, but the voting threshold to make a change is the
It'd
same.
be the same.
Yeah.
Yeah, and one of the big takeaways, I hope, tonight is that I would say 80% of the amendment process, it's a public relations battle. And it sometimes requires knocking on doors. It sometimes requires email blasts that explains why voting in favor of this amendment is in owner's best interest. But Bruce, I'll have you take the next one from Pamela. Can you
Although-
present?
Actually, going back to, is it easier
Yeah.
to remove? I suppose that probably does depend on the state, actually, to some degree, because in Washington, depending on your circumstance, there may be cases where in order to add a new restriction, you need 100% approval, whereas a removal, you may be able to follow the provisions in the document. So it may be in some cases easier to remove than add. All right, so the next one is Pamela. Can you present an electronic vote ballot for an HOA matter without a special meeting? Yeah, so typically when you do either written ballot or electronic ballot, you're doing it in lieu of a meeting. And then there are specific procedures you have to follow to notify owners about that vote in lieu of a meeting. And typically the quorum requirement for a vote by ballot in lieu of a meeting is that you need to get as many owners to participate in the vote as you would have needed to attend at a special meeting.
Oh, did you see this next one by Joyce, Bruce?
Do you have to have a new plat map with surveyor's certificate if you want to change the boundaries of your HOA? That is a loaded question.
That's a fun one.
Generally speaking, you have to change the plat. Changing the plat is a difficult process. As far as I know, in some cases may not really even be possible at all.
You can do a replat.
You do yeah.
If you
Yeah.
have approval of all, I mean, once all the lots have been sold, though, you're going to need everybody to join together in that, are you not?
Yeah,
Yeah, you have to have an acquiescence. Yeah.
yeah. So Lawrence, just so you know, Bruce and I have this conversation frequently about what types of amendments require a plat amendment. There's not a lot of clear direction, but this is a fascinating question.
Or a property line adjustment to deal
Yeah,
with the problem
yeah,
is a
that's
lot
right.
easier.
Yeah, that's right. Now, when it comes to amending, there's a reason that we have close to 50 people on here. Is a lot of you like us, and the reason you like us is the way that we write, which is plain English as much as we can. And I'm going to give you an example here. The first person that can read this and quickly explain what it means, Bruce will send you a check for $1,000 out of his personal checking account. Now, here's why I bring this up. Very often, boards come to us and say, hey, we want you to help us with an amendment or some amendments. We've already drafted them. We just want you to approve it. And that's always a challenging request. But one of the things that Bruce and I really dislike is legalese and clunky language. And this is actually an example from some proposed amendment language from a board of directors that I said, are you crazy? I had to read this 5 times before I even knew what you meant. And then I rewrote it. And it took some time. But it means the exact same thing. Now, most of you can read this and you understand what it means. Now, the reason I bring this up is the amendment process can be expensive, especially if you hire a good lawyer. But a good lawyer, part of their job is to write language in a way that folks can understand. And I'm a big advocate of that because for most folks, this is the biggest financial transaction of their lives, purchase of real property. And to me, it's crazy that they are governed by a legal document that most lay people can't understand. And I don't think that's right. And so, one of the things that we do is we make every effort to try to write. There are some concepts in the law that we just can't get around, and we're going to have to use some legalese. But we approach amendments and the drafting of that language with the mindset of we need to draft this in a way that most folks can understand, because if we go to court to enforce this, we're much better off if we can show that this is plain English. Anyone can understand this. So I guess, and this is maybe a sales pitch, but don't ever go through the amendment process without using a qualified lawyer to help you draft that language.
Who works for Harker Lepore.
And whose name is Kevin or Bruce. Yeah, so that's the big takeaway. Anytime you have a lawyer amend your documents, their name should be Kevin or Bruce.
Hey, Kevin, just, it's.
Can you go back to that amendment? Because I have a question about it.
Yeah.
After every 30-day period, the final increase by 25. Okay, so every 30 days it increases by 25. Got it.
You're about to challenge my rewrite of that language, weren't you?
Well, no, I was just curious I was just looking at it because I missed that part.
Good.
Hey, Kevin, just, it's 6:45 and you look like you got a lot of slides there. So I'm just.
Oh, boy. You know what they say, time flies when you're having fun. I'm going to start cruising through. So presenting the amendments. Once you go through the process of getting language that the board and your lawyer is comfortable with, that's the time to sort of present it. And again, my recommendation is to present a draft to the owner, solicit feedback, and then make tweaks based on that feedback. I think it's a good idea in most cases to solicit feedback and commentary. And then once you go through that commentary, if there are substantive changes, make those changes before you put it out to a vote. Now, here's another thing that comes up a lot. We've had boards come to us and say, our documents are old. They were recorded in the 1970s. And we want to redo them completely, the CC&Rs and bylaws, but we want a red line. That presents a significant challenge for us, especially if we're completely redoing them. And so one of the things that we have long conversations about is how do we present this to the ownership? And I am in agreement that a red line is often the most easy visual way to see what changes are being made. But sometimes, especially if we're doing a full rewrite, sometimes that's impossible. But again, that's one of the conversations we have before we start that process. Now, let's assume we've got a draft language, we've got some amendments, the board's comfortable with it, the committees are comfortable with it, the association's attorney is comfortable with it. Now let's get it out to the owners to approve. Electronic voting, like I said, is my preference. It's, in my experience, an increase of voter turnout, the ability to record the records of who voted which way, very easy, it's inexpensive. Now, Joni, how old's my mom?
I have no idea.
She's older than you, I know, but she's in her mid-70s.
Oh, she is?
I think.
She doesn't look that old.
Well, here's why I say that. I feel like only old folks complained about the price of postage stamps. Which last I heard, Emma, what is first class mail right now?
Our office has it for 60 cents, but I think that means it's a little bit higher.
So it's expensive. And if you've got 100 lots and you got to do them, it can get expensive. And so the reason I say it's inexpensive is those postage costs. I've done a lot of electronic voting in associations that have 300-400 lots or units. The postage for that can be expensive. So electronic, if you are authorized under the law and under your governing documents to do so, is, in my experience, preferable. And we get immediate results. So each time a vote is submitted, it goes into a database, and anyone that has access can see how many votes we're at, who has voted. And sometimes it requires knocking on doors to get the requisite number of votes. Now, with any type of voting, electronic or otherwise, there's always potential issues, duplicate votes. Now, here's a trivia question. Let's say there's an amendment, a ballot goes out, and the property is owned by husband and wife. Husband votes yes, wife votes no. Which vote do you accept?
Both.
It depends on your bylaws. In our bylaws, it says that the owners have to vote the same way.
Yeah, here's my advice. Always take the wife's vote. Always. I'm
Not
kidding.
helpful, Kevin.
Yeah, no, I'm kidding. Yeah, some documents actually specify what you do in that circumstance. Or sometimes you might have properties or units owned by an investment group that might have 10 different individuals. But yeah, it's going to depend on your bylaws generally about what you do in that circumstance. Now, what do you do with owners that don't have access to the internet? And every community usually has a handful of those. In that case, you do the old-fashioned way. So if 99% of the owners are going to do it electronically and 1% doesn't have internet, doesn't have an email address, you send it the old-fashioned first-class mail, generally a paper ballot. They fill it out, send it back, and then that ballot gets recorded in the total voting. So, well, I am really bad on time. So here's just sort of a screenshot of an electronic ballot where the owner says yes or no on the amendments. They put in their name, the address, their lot number, electronic signature, hit submit. Once they hit submit, it goes into a spreadsheet, and we have a live view of how many votes are yes and how many no. Pretty slick system. Now, in Oregon, and Bruce, I'm going to turn it over to you for about 60 seconds to talk about amending governing documents and the requirements for Oregon condominiums, because at least 3 of you I know are Oregon condominiums.
The amendment of the CCNRs requires 75%. Bylaws typically require a majority, but I think there are some statutory provisions that say certain types of restrictions, the bylaws require 75%.
Yeah, and after 5
yeah,
years.
I'm not finished.
Oh, sorry.
For any amendments to the CCNRs, you also require approval from the Oregon Real Estate Agency and usually also the county assessor. For bylaw amendments, if your condominium was created 5 years ago or less, you're going to need real estate agency approval of that amendment as well.
Yeah. And then assuming it's approved by the requisite number of votes, then we move into what I call the certification phase, which is where the president and secretary certify. Now, again, your governing documents might require signatures and notarization of owners. If that's the case, you have to do that. But in a lot of cases, it's the president and secretary simply certify that, yes, they received the requisite number of votes. Now, Bruce, are any of these amendments effective before they're recorded in the county recorder's office?
Usually, no. If your bylaws have never been recorded before, and then you amend them, I'd say that's typically effective. Of course, that would apply more to a planned community than a condominium, but I'd say 99% of the time the answer to that is no.
Well, folks. We've got
You
8 minutes. For...
you sped up really fast and got done early.
I did. I went a
got
little
quiz.
too fast.
I got a quiz question for you, Kevin.
Please, let's hear it.
So, owners meeting. This is a hypothetical. This is like a law school quiz. There's an owners meeting. More than 75% of the owners are in attendance. An owner stands up, makes a motion, says, "I move that we amend the CC&Rs to include a rental cap restriction of 25%. Everyone in attendance votes in favor of that motion. After the meeting, the board of directors drafts the amendment and records it. Is that valid?
I don't think so. I think that the ownership has to vote on the exact written language of the amendment.
I agree.
Yeah.
That was a quiz. I didn't know if you're going to get that right, though.
Well, Bruce, I usually get things right most of the time. Now, this is a fun topic. We do a lot of amendments. And like I said, part of the fun is the PR strategy. In other words, how do we structure this? How do we sell this? How do we pitch this in a way to the ownership that they're going to vote in favor of it? And that's always the fun part, but yeah. Dennis, I'm going to
Yes.
make one quick comment, which is I was telling Bruce this week that, you know, when the pandemic hit, I stopped going to owner and board meetings and mostly Zoom. But I'll tell you, I had the time of my life when we had your owner and board. I think it was 6 hours long, but it was the most enjoyable legal experience I've had in years.
Wonderful. We'll do it
And
again.
I see Mary, one of the other board members there.
Mary Lee's there, yep,
Yeah,
yep. And you got
This is-
a view of the ocean too.
that was a big part of it. Did you notice where I sat? It was strategic so that I could see the board, yet out of the corner of my eye, I could still see the waves in the ocean. So it was
And
fun.
that was a high tide weekend too.
Yeah.
Yeah, great.
Tiana, you have your hand up. Fire away.
I have a question. So I know that normally you should hire an attorney for amendment or bylaws, but after 5 years, you can do it yourself. What if it's simply changing something like 2 pets, 1 cat and dog to just 2 pets? I mean,
Bruce, I'll let you answer that.
You should always hire an attorney. No, I mean, the thing is that when you're amending your documents, it's important, I think, to make sure that you're not creating